From the Library of Congress in Washington, D.C.
All right, everyone, I think we're about to get started. This is the Section 1201 rulemaking. We're having a hearing on Class 6, which is computer program / jailbreaking. In this discussion, the Registrar of Copyright has already determined that she may tentatively recommend renewal of the existing exemptions for jailbreaking, and so we're really focusing on the legal and evidentiary basis for whether or not to expand this exemption to voice assistant devices. I think I see some repeat players and some new participants. So to explain our process, if you want to speak, just tip your placard up. The microphone, if you can turn it off after you're done speaking to prevent feedback, and also remove your phone from being too close to the microphones to reduce feedback. And we have a couple of exhibits. I'm aware of at least 2. And so if you're intending to refer to demonstrative or other material, just sort of say that in your speech. So when we read along in the transcript later, we'll understand how to tie that together. So we'll start with introductions. My name is Reagan Smith. I'm Deputy General Counsel of the Copyright Office.
Julie Saltman, Assistant General Counsel of the Copyright Office.
Kevin Amer, Senior Counsel in the Office of Policy and International Affairs at the Copyright Office.
Anna Chevet, Assistant General Counsel at the Copyright Office.
John Riley, Attorney Advisor at Copyright Office.
Stacy Cheney, Senior Attorney Advisor at NTIA, National Telecommunications and Information Administration.
And then if the participants wanted to state their name and any institution or organization they're affiliated with, starting with Mr. Freeman.
Jay Freeman, Soric IT, developer of Cydia, alternative app store for jailbroken iPhones, member of Exploiteers, a group which jailbroke the Amazon Tap, although I did not personally work on that project.
Mitch Stoltz, a senior staff attorney with the Electronic Frontier Foundation.
Matt Williams from Mitchell, Silberberg, and Knupp. I'm here for AAP, ESA, MPAA, and RIAA.
David Hughes. I'm the Chief Technology Officer at the Recording Industry Association of America.
Jonathan Zook from the Innovators Network Foundation, speaking on behalf of ACT, the App Association, because every time I think I'm out, they pull me back in.
Thank you all for being here.
So I think to get started, it would be helpful for us to hear first from the proponents about essentially to elaborate on some of the evidence that you provided in your submission. Just by way of background, as I think we indicated, there is an existing exemption for jailbreaking, which applies to smartphones and portable mobile computing devices. The request here is to expand the exemption to encompass voice assistant devices. And so I think to start, Mr. Stoltz and Mr. Freeman, it would be helpful for us just if you could kind of elaborate on the evidence that you submitted. I know you submitted 2 statements from people indicating the need that they have for jailbreaking voice assistant devices in particular, the types of activities that they would like to engage in. If you could talk a little bit about that, that would be helpful.
Thank you, yeah. By and large, many of the reasons why people are looking to jailbreak voice assistant devices are the same reasons that they would do so for smartphones and tablets and other mobile devices. There's an additional element when we're talking about voice assistant devices in terms of fine-grained control over privacy, which is really a major impact with these devices, simply because they are fundamentally an always-on microphone in the home, and because they're used to control other devices in the home, thermostats, home security, appliances, lights. They're potentially connected to those things, and a stock voice assistant device will have certain functions and capabilities with respect to those devices, and for the most part, it's collecting everything it hears and storing everything, at least temporarily, and then when requests are made, sending and potentially at other times sending voice information from the home back to the manufacturer's servers, which is both powerful and a bit scary. The ability to jailbreak creates the ability to be more selective. For example, limiting the range of the microphone to a smaller radius near the device, limiting it to certain hours of the day, limiting the time and scope of control over other appliances, and auditing what gets communicated to the server on an ongoing basis. Those are all reasons that people would need to jailbreak a voice assistant device.
Can you elaborate on that in terms of the maybe current exemption for jailbreaking, which is to jailbreak a certain category of devices for purposes of either adding, making software that is interoperable with a smartphone, for example, or removing software? When you're talking about these privacy concerns, I'm wondering from like a software perspective or an application perspective, what is actually happening when you're jailbreaking this voice assistant device for that purpose?
That would likely be something like a network firewall, or an application that sort of overlays the applications already installed on the device and limits their use selectively.
So, and just sort of picking up on that, so is the process of jailbreaking a voice assistant device different somehow than the process of jailbreaking the devices covered by the existing exemption? Is it fundamentally sort of the same thing, or is the process somehow different with respect to voice assistant devices?
So the hardware is a bit different, and although it bears some similarities. The Apple HomePod, I understand, is an iOS device, very much like an iPad or so on, as far as its architecture. The Google and Amazon devices are similar in certain respects, but the overall process is similar, which is to say you need to take advantage of some security vulnerability on the device to cause it to give super user or root privileges to the owner, which would normally be withheld. And in that sense, it's the same. It's going to involve usually either installing some external software on the device or making a small modification to the software on the device that will then cause the user to get root privileges. Actually, Mr. Freeman has actually done that, been through that process, and probably can talk about it in more detail.
Maybe, Mr. Freeman, when you talk about it, you can, consider in your answer focusing on what are the actual acts of circumvention, like perhaps this is circumventing some user restriction to be a super user, as Mr. Stoltz said, but, explaining it from a technological perspective with that in mind. Thank you.
So the general process on these devices, both the ones that we have existing exemptions for and for these smart speakers, is that there is a secure boot process which is designed to verify that the operating system and the software often that is installed with that operating system has come from the original device manufacturer. And in order to, and nothing has been added, nothing has been removed. And in order to make such modifications by adding, disabling, removing, overlaying, etc., requires finding a vulnerability or some kind of bypass to that signature verification scheme. In some cases, this is a matter of finding a bug. So there might be in the certificate, the thing that's checking the certificates, a mistake in how it is reading the certificates that you can take advantage of by putting in a slightly malformed certificate. Or in some cases, it requires making even a hardware modification momentarily. So in the case of the, and that is actually one place where I think there's a little bit of more, like almost more extreme work that is done with these smart speakers, is that some of them don't have any USB ports. And so oftentimes it requires soldering something to the board or a custom makeshift cable for a port that wasn't really a port.
Is that circumvention of a technological protection measure?
So, yes. So actually, if I could continue this, so on the Amazon tap, the way that the exploit worked is you have this secure boot process, as I was just describing, and then it loads into its memory area all of the information about those certificates. If you essentially short out the device at the moment that it is loading all those variables, you can cause it to not load those variables correctly. And so there's this technological measure, which is that signature verification process, and then there's this this bypass of it that we're performing by doing this kind of hardware manipulation that then allows us to get into the system, which then also further will require you having a way of communicating with it, which then requires us to have a cable plugged into it in order to do this. So.
Now, one thing that's new about this request, in addition to extending the exemption to voice assistant devices, is the language that would allow people to circumvent for purposes of enable or disable hardware features of the smartphone or device. Could you talk a bit about the rationale for that? Is that sort of, and I know in one of your papers you indicated that your understanding is that's sort of implied in the term jailbreaking generally. So is this primarily just for sort of clarification to make that explicit, or is there a particular additional reason, maybe related to the privacy issue you talked about before, that would warrant this expansion?
You're correct. That is, we put that in not to expand the exemption, but to clarify it. The ability to install software of one's choice, install or remove software of one's choice from a device necessarily implies the ability to enable and disable hardware features. The reason we added that was to emphasize that, for example, the examples I mentioned just now, things like limiting the range of the speaker or turning it off at certain hours, or causing it to potentially only respond to certain voices, or to turn off particular wireless interfaces. All of those things are important and should be sort of made clear that those are encompassed in the exemption.
Now, to the extent that your concern is disabling the data collection and transmission feature, I mean, would that aspect be covered by 1201I, the current personally identifiable information? I understand that what you're seeking is to do more than that. You want to install apps and so forth, but I just wonder if you've considered the extent to which 1201I might be relevant to the privacy issue.
It might in some circumstances, but not in all the circumstances we discussed in our papers.
So I appreciate that you're raising privacy controls as a reason why someone may want to jailbreak these types of devices. I'm wondering, would your petition also allow for jailbreaking to install applications for increased surveillance? And if so, how do you think the legal basis for that exemption is non-infringing, and justifications for that would be the same or different?
So by the term increased surveillance, I'm not quite sure what you mean.
Well, I agree that it's broad, but I think you can sort of guess out, right? If you have a Amazon Echo or something, and right now the relationship is between the user and perhaps Amazon, could you install a device that would go to a third party or to another app? I mean, just if you think no categorically, maybe explain why, and trying to restrict the scope of a device to minimize impact on privacy, it also implies you might loosen up restrictions.
So, we're talking here about a device that a person owns and modifies for their own use, and you could imagine a scenario where you want, for example, you wanted to use turn a voice assistant device into an audio security device, or perhaps a baby monitor, with features that are not available from the manufacturer. Those would be, in a sense, modifying it for increased surveillance, but with the on the initiative of the owner of the device. I'm not clear on why that would change the infringement analysis. I also think it's important to point out that those same concerns would apply to a smartphone, and they have not been raised in this proceeding or in previous proceedings.
Thank you. So I wanted to ask the opponents specifically about the request to add this new language about allowing circumvention to enable or disable hardware features of the smartphone or device. I just would like your views on that specifically. We'll get to other objections you may have to other parts of the request, but do you have an objection specifically related to the addition of that language?
I think, like you, I'm not entirely clear on everything that it covers, which makes me nervous. I don't think in and of itself that we're objecting to that, but we are objecting generally to the expansion to additional devices.
Mr. Zuck?
Thanks. And I apologize in advance for not being a copyright attorney, and so I don't know always what's relevant and not relevant. But I guess my concern about this expansion to hardware features is related to something we raised in our testimony about alternatives that exist to create alternative hardware to get to these services. And so at some point I'll be talking about that, but I guess I wanted to create a placeholder here that the more that you're trying to modify the functioning of the device, the more it suggests the creation of a competitive device with similar underlying features that as a better alternative than creating all the attack vectors and things like that that jailbreaking these devices would encourage, whether it's copyright infringement or not.
Well, that leads us into, I'm sorry, Mr. Hughes.
Thank you, Mr. Yeah, and I'd like to come back to my point a little bit later as well, but Mr. Stoltz made the comment that that one reason to jailbreak these voice-assisted devices is to turn off hardware features, and I just want to stress that those hardware features, in some cases, are an integral part of the security that is provided by the device on behalf, I suppose, if you think of it in terms of contractual relationship, on behalf of the service that is distributing the music of my member companies.
Could you provide more specifics if you know the specific hardware features, or also discuss whether this may be of particular concern in the context of voice assistant devices?
Yeah, so as the gentlemen have mentioned, each one of these devices is built differently. They're built on slightly different platforms and so on. But let's focus on the Amazon Echo device, the one I'm most familiar with. It is also the most dedicated device, and it's a $50 device. It is not a multifunctional, general-purpose computing platform that can do all kinds of things. I'll give you one example and then come back to your question. When you're on a personal computer, for example, and you introduce secure media, let's say, from my personal experience at Sony Music, we worked on DVD audio and Blu-ray audio, things like that. There's a combination of the hardware and software that, for example, turns off the unsecured digital outputs. That protects our music. In these devices, it sounds to me that if one of their purposes is to start to turn off hardware features, that my concern would be that there is going to be some unintended consequence whereby suddenly music that was licensed for an end-to-end secure distribution is no longer secure. And I can come back in more detail later if you should.
I have one follow-up to that. So this is getting us into the sort of, I suppose.
That's why I wanted to put a placeholder, but yes,
yeah,
go ahead.
the kind of heart of the matter, I suppose, which goes to the piracy risk. I guess just one follow-up, Mr. Hughes, to your point. I mean, is that concern something that exists in a more significant way with respect to voice assistant devices than it does with respect to other types of devices which are already covered by the exemption?
I think it does, and the example I give is that the manufacturers of these devices are trying to minimize their cost. They're trying to sell, in the case of the Amazon Dot here, a $50 device. They're not incorporating the kind of hardware and software complexity that was in a personal computer, for example. So the options for security are quite limited. And once you take away that basic security, that was the assumption that my companies had when they did a deal with a digital service provider who did a deal with these services, there's not a lot to fall back on. And that is our concern, that there will be I guess, just unintended consequences.
So the cost of the device is...
The simplicity of the device might be a better way than focusing on cost.
Okay. I'm going to let Mr. Zuck make his point and then give Mr. Stoltz and Mr. Freeman a chance to respond. We may be getting into the piracy issue, which is fine.
And I may be guilty of that as well, but David's point sort of reminded me of another point which had to do with analog versus digital, and that the absence of ports in these devices makes it difficult to make high-fidelity copies of content, et cetera, that are coming off the machine, but the insertion of additional hardware and creating a hardware connection to the device in the form of a port, which the purpose of which is to add things to the device, could also be used as a way to digitally remove things from the device or copy things from the device in much higher fidelity than would be possible than getting something off of the speaker.
Thank you. Now, Mr. Hughes, I do want to follow up to a point that you made about the contractual relationships, because I think that's important here, because we're talking about, who the owner is of the TPM. I mean, our job is to consider whether circumvention of that TPM is going to have an adverse impact, and the use of the copyrighted work that is protecting is non-infringing. As I understand it, I mean, you're saying that you have contractual relationships with service providers, Spotify, Pandora, et cetera. And I can understand in sort of, forming those contractual relationships, it would be important for you as the content owner to ensure that those services have adequate access controls preventing, unauthorized access to your works. But this is then going a step further, and I don't understand, I haven't seen any indication that as part of your negotiations, and you can correct me if I'm wrong, that you then dictate or you expect the services to, provide requirements as to the types of access controls that the device has with respect to its firmware. It seems a little bit attenuated from the sort of normal, process that we consider.
So the deals historically that I was involved with when I was previously at Sony Music, for example, we did a lot of due diligence, and we specified very precisely what kind of security measures we intended to have in place for sometimes called end-to-end or link or whatever the term you want to use to protect the music. And those are articulated, and I cannot get into the details of the contracts between the member companies and the services, but it is reasonable to assume that those are in all of those contracts. And that if those services then do a deal, for example, to enable access to Spotify from a voice-assisted device, that Spotify understands that they have an obligation based on their relationship. So I understand that it is not a direct relationship, but it is the basis of the business negotiation and the business of the business offering. There's an assumption that the music will be kept secure, that if it's not, a subscription service is, the viability of the business service is threatened, is it not? If people can get access to a Spotify for free, for example.
But in EFF's papers, they made the point that, Spotify does, you don't prevent Spotify from streaming to personal computers, for example, which at least according to, and you can correct me if I'm wrong, but according to EFF's experts, typically don't prevent users from having root privileges. So there isn't the same type of restriction that would prevent, the installation of.
So
of
I'll give
apps.
one example, and experts can correct me if I'm wrong, but even if I have root privileges, for example, on a personal computer, it does not mean that I can then get a clear, high-resolution digital output of the secure media that I put in on my Blu-ray disc, for example.
And your concern is that in the case of the Amazon Echo, for example, having root privileges would enable that access on that device as compared to.
I think it is reasonable to assume that the level of complexity of the hardware-software combination is not there to provide the kind of security you'd find on a general-purpose computing device. For example, the ability to extract the music data from the buffer and offload it to a hard drive, for example. I can imagine, I have no personal experience researching this in detail, but I can imagine that on a device that would not be particularly difficult to do. Now, please feel free to ask these experts as well.
Well, thank you. So, Mr. Stoltz and Mr. Freeman were next, and then I'll come back to you, Mr. Williams. Mr. Stoltz.
Thank you. So responding to a couple of things here. On the point about whether voice assistants are general purpose computing devices, I'm reading here from the printed booklet that came with an Amazon Echo Dot device, and it lists, it's got 5 panels that say,
Is this something you'll be able to share with us after so that we have a record of it?
I'd be happy to. I apologize that I only made one copy, but I'd be happy to submit this by email or make photocopies.
If it's possible after the hearing, if you can leave that copy with us, we'll mark it as Exhibit 6C, I guess, if you're comfortable. I think that would be useful so we know that what we have is exactly what you're here reading.
Absolutely.
Okay, thank you.
Yeah. It has various panels that describe what it does. It says Alexa skills, voice shopping, fun and games, and music unlimited. That's the last panel on there. The point being, music is one of many functions of this device. With skills in particular, there are thousands of them, although for reasons I can get into, what can be done with skills, there are limits imposed on what can be done with skills, absent jailbreaking. But all of these devices run some variation of Linux or iOS, or potentially Android, variations on the same operating system that runs a smartphone or tablet. They have varying degrees of memory and storage on them. And I think this is a very important point, right? They are designed, marketed, advertised, and primarily used, and there's a quote in our first round comments about the reasons why people use voice assistants. And it is for all of those purposes. It's for communications. It's for simply accessing information on the internet of all sorts. It's for again, home control. So I guess I take issue with this idea that because the device is cheaper and perhaps smaller, that it's not a general purpose device. Again, that's how it's designed, that's how it's marketed, and that's how it's used.
Well, so could you respond to Mr. Hughes's argument, as I understand it, that it is, and correct me if I'm mischaracterizing what you said, but that it's easier to capture without authorization a high-quality copy of a work from a streaming service that is streamed to a jailbroken voice assistant device than it would be streamed to a personal computer, for example?
So no, I think it's no easier. And the point that I think that we may be kind of missing is just, soldering a new port onto the main board of a device may or may not be circumvention. Probably in many circumstances it will not be. It could be in some circumstances, but that's something you can do on any sort, on any sort of device. As for whether that's sort of physically easier or not on a voice assistant versus say a smartphone, again, for example, the Apple HomePod is, as I understand it, essentially the same hardware as in a phone or tablet as far as its computing capability. Both run the iOS operating system. With other devices, we are into the realm of pure speculation here, which I think is not, which is not a basis for
Right,
for,
but,
for
I mean,
decision.
you're asking for the exemption, and we would prefer to not be in the realm of pure speculation. If there's a way to understand what technology is at issue, I think I appreciate you making the functional argument of how these devices may be used. But in the past, the Copyright Office has looked at this from a technology and what TPMs are in place when considering whether or not to extend an exemption to video game consoles, which was denied in part because I think out of a similar scenario to what Mr. Hughes is saying. And on the other hand, there is the smart television exemption, which is coded separately in the CFR. And the record for that, the last cycle, determined, I guess, that there were separate TPMs that were protecting the entertainment context, so that it would be appropriate to grant an exemption to the smart television circumstance. So I think that's why we're trying to understand whether what Mr. Hughes's concern has whether the basis weighs out when how the technologies works.
Sure. There are TPMs that apply specifically to entertainment content. And they are, while I don't know which devices use which ones, they are available to voice assistant devices. They certainly have the computing power and the technical ability to use the same sorts of TPMs that protect streaming to other devices. And there are additional TPMs, which I should add, those TPMs are not covered by our exemption. They may be covered by others. And there are also TPMs that exist on the server side. Most of the sort of speculative sort of doomsday scenarios in the opposition comments, for example, accessing a music streaming service on multiple devices when one is not authorized to, that's instantly detectable on the server side, which is out of reach of both the customer and this exemption.
Mr. Freeman?
Yeah, so I mean, on partially on this topic, I mean, I'll bring up, there was a statement that on desktop computers that somehow not having root access is not sufficient in order to be able to get access to the digital information that is being transferred. And generally, with a general purpose computer like that, the information is being decoded and then being sent to the display output. It is going through regions of the computer that are accessible either to the root user or are trivially replaceable by the person who is owning the computer. But then, as Mitch is saying, that there are cases where on an embedded device, you can add essentially an additional level of technological protection measure, which is typically very separate from the general purpose computer parts of the system, the type of sections that might be running the voice assistant software. And as Mitch is saying, that you can essentially have a circumvention that circumvents those general purpose computer mechanisms that don't circumvent that extra level of media protection. But that is not really the case on general purpose computers as far as I have seen in myself. I also wanted to comment on this, kind of follow up a little bit on this idea of these devices being used almost entirely for music. I mean, I know many people who have them and they don't seem to be using them for music. They actually are using them for what I had actually always myself thought was one of their primary features, which was these voice assistant softwares, the ability to ask questions and get interesting answers. I have friends who have it, so they have controlled their entire apartment using one of these voice assistants, and so they essentially just, okay, Google, turn on my lights, rather than having to bother going and getting up and actually messing with switches. As far as hardware features disabled, I mean, we have some interesting concrete examples that might be a little bit easier to conceptualize. On the Google Home device, there is a touchpad which can be used in order to enable the voice recognition components and to start sending information to Google. And when that device was shipped to users, that touchpad was actually faulty, and there was no good way for Google to fix the touchpad. And so what was happening is that it was activating even when no one was talking to it, even when no one was touching it. And it took a while for Google to be able to release software updates that would disable all of that. But that's the kind of thing where it's users who have that device would like to be able to disable faulty mechanisms on the device.
And do you think that would be covered by 1201I?
No, actually, I do not believe it would be covered by 1201I because the modification, sorry, the definition on 1201I, which I'm trying to, here we go, specifically states that the act of circumvention has the sole effect of identifying and disabling the capability described in subparagraph A and has no other effect on the ability of any person to gain access to any work, while the mechanism that you would have to modify in this case would be the protections on the general purpose computer parts of the system, which oftentimes will be used for copyrighted works. While there is the possibility that a device can have an additional mechanism to protect certain kinds of classes of work, that it is almost essentially never going to be the case that all classes of work are going to go through that system, and many devices won't have that extra separation anyway. And the final thing I wanted to kind of just reemphasize was something that was brought up by Mr. Stoltz, which is that the Amazon Echo it's a device that, as he states, has it's built in the manner of a general purpose computing device, but it has 256 megabytes of memory. It has 4 gigabytes of flash storage. It's a little smaller than the smallest iPod as far as the amount of storage and memory it has, but it's not orders of magnitude small or anything. It is in the same realm as an iPod. And in fact, the system on a chip that is used on these devices is the same system on a chip that is typically used for smaller tablet computers. This is a device that is running a general purpose operating system. It was a device that is using general purpose hardware to run that general purpose operating system. It has simply been configured into a form factor that happens to not have a port on it, and it is configured with a locked down software mechanism similar to the signature-based verification that is used on these other devices that we have succeeded in getting exemptions for.
Thank you. Mr. Williams?
Thank you. I have a few points since a lot has been said. I've got kind of a legal point, a factual point, and then a point about how the record's been characterized. So we had a similar conversation a couple of days ago on Class 7 about who owns the TPMs, and I just think that's the wrong question to be asking. I don't think there's anything in Section 1201 that instructs you to be looking at who owns the TPMs. There's a number of reasons why I say that. So number one, under Section 1203, it is not the owner of the TPM exclusively who can bring a civil action. The copyright owner who is protected, in this case, for what we've been talking about, the record labels, could bring an action regardless of who owns the TPM if they're harmed. Another thing is if you look at the factors that you're instructed to apply in 1201, it talks about looking at the availability of works for use, and it talks about harm to the copyright owners of works generally, not just of the owner of the TPM, not just the owner of the software that is accessed without authorization, but any downstream harms are also supposed to be considered. And I don't think, at least from the copyright owner's point of view who are represented here today, that the access control on the firmware is just something incidental. I think it's wrong to assume that they don't take it into account when they are entering licensing agreements, and I think we have testimony that says they do. That gets me to the point about the record, Mr. Stoltz.
Can I interrupt
Sure.
you? I mean, you know, and that's helpful. I went back and I was looking at the legislative history. I mean, and there's a line in the Senate report, Judiciary Committee report, page 28. It's talking about Section 1201A. It says, Section 1201A applies when a person has not obtained authorized access to a copy or phonorecord of a work that is protected under the Copyright Act and for which the copyright owner has put in place a technological measure that effectively controls access to his or her work. I mean, doesn't that suggest that what we're talking about here is, you know, the effect on the possible infringement of a work for which the copyright owner itself has put in place an access control?
I'd have to look back at the context of that. I do have the legislative history with me, but I won't be able to pull it up quickly enough. I don't think that that's accurate because, I'm sorry, but which version of the report did you say it was in?
This is the Senate report, Senate Judiciary Committee report.
Okay, so I'd also have to look back at, you know, of course, the language changed over time going through the conference, and so I'm not sure. Again, I'd have to look at the context, but I think if you just look at the statute, it's clear the copyright owner can bring an action regardless of whose TPM is at issue. And even the language you read, I think there's going to be very few circumstances where it's only the copyright owner alone that's involved in placing a TPM onto a work. I mean, if you think about it, a songwriter who owns the rights to a musical composition that's distributed through a streaming service isn't going to be involved in the technical process of putting it on there. What they might be involved in doing is negotiating for protections through the distribution system as best they can, given the leverage that they have in any given negotiation. And so I think to say that because a device manufacturer or a service provider who's licensed is the one who technically implements the measure, that the copyright owner has no recourse or isn't the intended person who's being protected is just, I think that's completely wrong when you look at the statute.
Okay, but I interrupted you, so you had another.
No, thanks for that, and I'll try to take a look at the legislative history when I have a chance, and I'm happy to follow up in a letter as well. Mr. Stoltz had said that it's just pure speculation in the record, but we've got two technologists. We've got the statement from Chris Bell. We've got Mr. Hughes here today. They're testifying as to their best understanding of how these technologies work and the risks that are presented by the circumvention. So to call that pure speculation, I think, is just incorrect. When you talk about the record last time and the smart TV expansion, you know, and I'll take the blame for this, we didn't have that kind of direct testimony from technologists in the record. I think we did have a lot of evidence of the harm that could be caused by jailbreaking smart TVs, but it was determined that it wasn't enough, and so that was granted. But we did not have the types of witnesses we've had providing testimony this time. That brings me to one of the arguments that EFF made in its reply and that I've heard again today, which is that, well, we have to show some harm caused by the existing exemptions, or else you should assume that no harm will be caused by expansion. And I think that's wrong on multiple points. First, procedurally, this is a new issue and they have a burden to meet. But more importantly, we have shown harm, I think, in every single cycle from the jailbreaking exemptions that exist. The office has concluded that it wasn't enough to stop issuance of the exemptions, but we opposed it in the beginning. We opposed it for multiple cycles. The office decided to grant the exemption, ultimately to expand it, and we did not fight renewal this time because we respect your decision-making processes. But that doesn't mean that we don't see harm in the market, and the exhibit that we submitted today shows you extensive harm that's being caused by jailbreaking, especially through the Cydia platform that Mr. Freeman has made available to everyone. There's, in the exhibits, documents showing that things like Spotify Plus that basically enable you without paying to get all the features of a premium Spotify account, similar apps available through Cydia for Pandora, for YouTube Red, for installing popcorn time, which we talked about when we were talking about smart TVs, in a manner that you wouldn't otherwise be able to install it to get access to unlawful copies of movies. If you just Google around a little bit about Cydia, you will see extensive evidence of harm to my clients. And so the fact that we haven't fought renewal this time is not an admission at all that there's no harm being caused. And the fact that that harm has already been caused and that to some degree those exemptions are water under the bridge is not a good reason to make the same mistake twice. We're here to put evidence in that shows there should not be an expansion to this new model of dissemination.
Thank you. But are you saying that the harm is greater in the context of voice assistant devices than it is with respect to other devices? Because, and I take your point about, not wanting to sort of relitigate these issues, but you didn't oppose the renewal of the existing exemption. You're opposing the expansion. So, I think we'd be interested in knowing if the harm that you're talking about is greater in the context of voice assistant devices.
Sure, and just two things on that. I mean, one, we tried to be as cooperative as we could during the study process that resulted in the more streamlined renewals, and we accepted the definition of meaningful opposition, and that required us to either show a change in the law or a change in the facts. We feel like we put evidence in before about the facts that piracy was being enabled, and we at that time did not see a change in the law. Had the Oracle decision, which I hope we discuss at some point today, come down before renewals had to be opposed, we might have made a different decision on that, because I think the law is clarified by that decision at the very least. But getting to your question, I think Mr. Hughes can speak to it, and he did a little bit already. The concern is that this is a really important platform going forward for my clients. People are going to be using these types of devices in the home around the clock to enjoy entertainment content. And as Mr. Hughes was saying, to some extent they are simpler devices, cheaper devices than a personal computer. There's not as many ways to protect the content. And so removing any one piece of what he described as the end-to-end system of protection on these exposes the works, we believe, to more threat than perhaps on some of these other devices. But that said, there is threat on the other devices as well, and I don't think we have a burden to show that the harm here is going to be greater than the harm on these other devices. I think they have the burden to show that the availability for use of works and the value of copyrighted works will not be harmed by the expansion. And I think we've got enough in the record to show that those two factors favor our side.
So just to make sure I understand Cydia, which is your exhibit 6A, this can be installed on both the all-purpose devices, things for which there is an exemption, as well as voice assistant devices?
So, and Mr. Hughes may have something to say about this, and I'm sure Mr. Freeman can speak to it. I don't understand all of the technical aspects of Cydia, but my kind of layman's understanding of it is when you jailbreak, your mobile device, you install Cydia so that you can essentially get access to a huge variety of applications, many of which are of the sort that you have there in the exhibits and that enable unauthorized access to works.
Mr. Freeman, do you want to answer that question too?
So to describe maybe a little bit more simply as far as what, so Cydia is kind of like the Apple App Store. It's a project where you can scroll through and see things that you can install on your phone. As described, it is typically installed with a jailbreaking application, something that is designed to bypass the restrictions on the phone's ability to have added or removed software, but it is not itself a circumvention mechanism. It is something that can be installed by a user on that device.
Okay, so if I want to use Cydia, and
Yes.
you've helped make Cydia, right? You install something to do the jailbreaking, then you install Cydia, which is like an app store, and then once you get on Cydia, Mr. Williams has suggested it offers a variety of like unlicensed.
Yes. So
entertainment.
sorry.
Okay.
All right, yeah, so the Cydia then itself works in some ways, I would say, similarly to a web browser. It does not, so Cydia is not a centralized managed store. So I am not in charge of determining what is or is not available via Cydia in the same way that the people at Mozilla are not in charge of what is available via Firefox on the internet. Some of this commentary here about how if you just Google around, you'll find extensive evidence of people being able to do things, with Cydia. It's like you just Google around and you'll see people talking about all sorts of things you can do with the internet. I then think it's actually worthwhile pointing out that, on this pile of paper, this very first thing here where it says Cydia iOS 7, if you go a few pages in, it actually states, disclaimer, CydiaIOS7.com is not owned by, is not licensed by, nor is a subsidiary of Apple Inc. and Sork IT. Cydia is owned by Sork. iOS 7 is a trademark of Apple Inc. And this is actually this is not Cydia. This has got a bootleg / modified icon that's designed to kind of look like Cydia. This is a third-party website service that is providing some similar looking functionality to Cydia. And some of these services actually don't even require jailbroken phones. And so from that point, I will then bring up that this functionality that's being described, for example, Spotify++ and the ability to essentially have modified versions of these applications, that's something that's available to people who do not have a jailbroken phone. On these devices, you have the ability as a developer to install software yourself. And what these services are now doing is they're simply taking the Spotify application, adding those mixing in those modifications to add these services, and are then offering them via app stores that, sadly to me, use my brand, and I oftentimes am trying to figure out ways of suing them to stop them from doing this and confusing it with a jailbreak issue. But this is actually something that's available to non-tampered, non-circumvented, non-jailbroken devices. And I kind of think that in many ways then a lot of this information is irrelevant to our discussion today.
Could I just jump back in, and Mr. Zuck, you've been really patient, so I'm going to get to you, but I just want to raise this to sort of, I think, try to focus the issue. So Mr. Williams, you mentioned that we have sort of competing experts here. We have your expert, Mr. Bell, and so I wanted to give you all a chance to respond to Mr. Schoen's statement that was attached to the EFF reply. He seems to be suggesting that there are a couple of layers of TPMs that would be relevant here. I don't know whether I'd be interested in your perspective on that. If you look at paragraph 6, he talks about how industry has arranged for these devices to access media, but then he says the device owner's root privileges typically are not sufficient to give the owner unrestricted access to those media because the application software used to decrypt and view those media enforces other restrictions or contains other technical measures that do not depend on controls in the operating system. So he seems to be saying that, as I understand it, if you jailbreak a voice assistant device, there is another layer of TPMs that typically exist in the device that prevent you from gaining access to media. And then he says, in addition to that, streaming media services can also use a variety of measures on the server side, which is kind of what Mr. Freeman alluded to enforce policies about unauthorized access to media. We have no idea, we have no way of knowing whether that's true or what your views are on it, but they seem to be saying that to jailbreak the device does not necessarily, that there is an additional layer of TPMs within the device in addition to any TPMs that exist on the streaming service side. Mr. Zuck?
Thanks. Sometimes it's you get all revved up to give a comment, and then you ask a more specific question, and you have to
sorry about that.
Reformulate. But
you've been waiting a long time.
No. The truth of the matter is that it isn't about a service like Cydia or a copy of Cydia taking responsibility for this. It's about the fact that what you're doing in this context with a jailbroken device is providing an alternate vector to get software onto a device, right? And that can be a good thing. There might be some availability of some software that wouldn't otherwise be available, but it can also be a bad thing because, while imperfect, these stores provide some curation and some protection, takedowns if somebody, you can escalate something if there's a problem. So if counterfeit software appears on a store, I can get it taken down more easily than I can on a browser-like service that's been described. So, for example, things like the ZIS or MRAT virus that has infected so many Android and iOS devices comes in a lot more through jailbroken phones than it does through regular ones. That doesn't mean that unjailbroken devices are perfect. They're not, right? But the jailbroken devices create a much more welcoming vector for these kinds of malware that come in the form of counterfeit software. Then do things like monitoring and things like that, keystroke logging and things. And because somebody thinks they're installing a piece of software that they would otherwise have to pay for on the iTunes store, but this version's free, why not use the free version? And so then now that creates a reputational damage to the software developer of the real piece of software, et cetera. So as Matthew said, these things are happening now today on devices that are a part of the exemption. And I guess I would suggest that, similar to the points raised by the proponents at EFF and elsewhere about the types of devices, I would say the stakes are risen for counterfeit software as well. In other words, the fact that I'm giving these devices control of my thermostat and other security measures in my home, et cetera, suggests that the introduction of malware is even a more serious threat in the context of these devices than it is in a smartphone. So that might be a little bit convoluted and only touch a little bit on what you're trying to say, you were trying to get at via this specific argument, but there is a vector that's in place. It has been used to introduce counterfeit software that then has malware attached to it, and I just wanted to make that point. Thanks.
Thank you. Mr. Hughes?
Yeah, so I was wanted to come back to your point that Mr. Shones had addressed. So yes, while it's true that there are certain things you can do from the server to secure the distribution, the secure distribution of the, in this case, music to the device, when it gets to the device itself has control over what happens at that point. And, you know, to quote Mr. Stoltz, one of the reasons to jailbreak is to turn off hardware features. Well, to me, I don't know exactly what that means, but if you're turning off hardware features, then things like preventing somebody from sucking all the music off the buffer and filling up a hard drive with thousands of hours of music could happen. And I just, you know, my reason for appearing today is just to have everybody consider the unintended consequences. And as I think Mr. Williams pointed out, in the past, the unintended consequences, well, perhaps not 100% well articulated in advance, we're seeing them now in the marketplace. And streaming of music is now 2/3 of our business and growing. And the voice access to these services is the fastest growing part of that service. So we see this as a part of, an important part of the future of our business. And we take any negative impact on that business very seriously, and we would like you to as well.
So how would the streaming market, what do you think would be the likely, bad case scenario for you? And we talked about exceeding subscriptions on the one hand, but that goes back to something that is maybe happening. I don't know if that's the example with once it's already on your device, you can't control it. How exactly would the risk to the streaming market work with this exemption?
Well, I don't want to contradict the EFF folks too much, but I suspect that it is possible, if you have jailbroken a device, that you could spoof IP addresses potentially, and if this device were in dormitories and colleges across the country, that single accounts could be providing music to multiple listeners and so on. And of course, on the server side, there are ways to detect this as well. But what is happening is that the business model was created based on certain assumptions of what security would be in place. And if those are taken away, the business will then have to respond. And that will either mean that the services on the service side and or in collaboration with the device manufacturers are going to have to reinvent the security that's being taken away. And that's not a good thing either. Does that address a little bit of what you're...
Yes, I think that's helpful. Yeah, thank you.
Let's go to Mr. Williams, because I'd be interested in whatever information you may have about my question about the nature of the TPMs, to the extent you have it.
Sure. So, and David's the technologist here, I'm just the lawyer, so I'll do my best to address it. But I think that the heart of your question as a legal issue is if there's any possible way that everyone involved in the dissemination ecosystem could redesign how the TPM scheme works that would enable jailbreaking while still protecting the content securely, then it's on us to redesign it that way. And I just don't think that that's a fair way to read the statute. I think, could it all be redesigned? I'm not so sure that it could in a way that would completely protect the content and allow for jailbreaking. But yes, I think there are things that the services already do on the server side to try to prevent some of this. Mr. Stoltz was referring to, well, if someone does what Mr. Bell's statement says they can do and spoofs the device, then the server will automatically recognize that. From talking to Mr. Bell, that's not my understanding. Yes, it's true that if you try to geographically distribute that all over the country, yes, I think the server would pick up on that. But if you were doing it, say, in a college dorm, in a number of different rooms in the same location, that my understanding is maybe that wouldn't be so easy to recognize. Again, I'm not a technologist, but that's my understanding. And so I do think that the record has identified some threats that just removing the firmware would enable. With respect to the redesign, my understanding is also that to the extent you increase the number of device-side TPMs that are necessary, the cost of the devices would likely have to increase over time. That a general purpose laptop, as Mr. Hughes was saying, has more capabilities than a $49 voice assistant device. And so I think there's a number of different things to consider. I did want to mention, while I have a chance, that I wasn't trying to say that Mr. Freeman himself is directly the one who's developing all of these apps that enable unauthorized access. But if you go through the exhibits, I think you'll see that in almost every instance, as they're providing the instructions, they say, number 1, jailbreak your phone. Number 2, install Cydia. Number 3, here's how to get our app, and here's how to start getting all the benefits of a premium service without paying for them. There's one in there, Mr. Freeman was saying, well, some of these you might not actually have to jailbreak the phone. And I've seen some things online that say that's the case, but there's one in the set of exhibits that says, well, don't believe anyone who tells you you don't need to jailbreak your phone, because if you don't, then every week or so Apple's going to cause these apps to stop working. And so as a technical matter, can I say whether you have to engage in circumvention to install all of these apps or not? I can't, but I know from looking at the description from the people who are encouraging everyone to install them that they almost always say you need to jailbreak in order to do this. The other thing is, if I understand the process that Mr. Freeman is referring to, there's a app or platform that I believe he was involved in disseminating that I think is called Cydia Impactor, and that this somehow allows you to what they call side load some of these apps onto an iPhone, even if you haven't technically jailbroken the iPhone. Now, it seems to me that involves an intentional effort to get around some measure that is otherwise preventing the installation of these apps. And so whether that's circumvention or not at a technical level, I couldn't speak to, but it sounds a lot like circumvention to me. And so whether you call it jailbreaking or you just call it circumvention, I think that's still something that you'd have to look at very carefully to decide that it's actually lawful.
Okay, I'm going to give you, Mr. Freeman, a chance to respond to that. But in addition, and this is for you too, Mr. Stoltz. I mean, in your answers, if you could, address Mr. Hughes's point that these contracts between content owners and service providers are negotiated against this backdrop of expectations about, the level of TPMs that exist throughout the ecosystem. And to remove one of those legs is going to be detrimental. That would be helpful for us.
All right, I have an answer for that too, so I'm excited. All right, so first of all, it was mentioned that if you go through here, there's a lot of mentions of jailbreaking. There's also a lot of old information that is in here. So the mechanisms that were provided for allowing arbitrary app installation on a non-jailbroken device are, in the grand scheme of things, relatively recent. So information from 2012, information from 2000, and even 2014 or 2015 sometimes is not relevant in that way. The fact of currently is that you can install without having to pay Apple any extra money, any application that you would like onto your device and this is key to respond to the comment that made it sound like Apple was shutting these things down. You can install it for up to 1 week. And that's not that Apple is figuring it out and then shutting it down or whatever. It's just that you can install anything you want, it runs for a week, and then you can install it again, and it runs for a week. It can be a little bit inconvenient that every week you might have to reinstall it, but it tends to not be you plug it back into your computer, and there are tools that will automatically reinstall all the things that you had. You just have to have access to a computer for 30 seconds once a week. The software that often is used to do these sorts of installations was mentioned, something I've written called Cydia Impactor that allows you to sideload these things. It is absolutely not a circumvention mechanism. This is a officially published mechanism from Apple. I just built software that made it a little bit easier to use. But you can download software directly from Apple that does the same functionality as Cydia Impactor, just it requires many more steps. And specifically, if you were to download their Xcode development environment, you can install anything you'd like by having Xcode install it. So now there's this question of how these like licenses and other forms of contracts are negotiated. I mean, one thing I think is worthwhile pointing out is that all of these services are available on other devices. I mean, you're seeing, for example, like Spotify, being referenced here on the iPhone. It's also available on Android. You can take these services and run them in emulators and copy off all the information. And part of the reason why is that, contrary to what has been, from my standpoint, weirdly stated over and over again, general purpose desktop systems have much less ability to protect content than even the most general purpose small device. And the reason why typically is that the people who make things like the iPhone or the Amazon Echo Dot, they're building the hardware and the software together. And they are building it with some of these ideas of what they might want to do with in mind. And so they can, for example, have an encrypted audio buffer trivially. It's very cheap for them to do that. Whereas on a computer, if you were to try to have these specific business model enabling functionality with upgrades from an operating system vendor that oftentimes is not the same company, even Apple trying to maintain over the course of a 7-year lifespan of major functionality modifications, they're relying on having much cleaner interface separation between all these different layers. So, I mean, we definitely have seen much more interesting and much more cheaply built, much more effective technological protection mechanisms on these smaller classes of device than on these general purpose computers. And yet, the services like Spotify, these services that are doing music streaming, are available on all of these devices. And yet, despite the fact that it is so easy for people to, for example, install something like an Android emulator on their desktop computer and then run Spotify and copy off the exact digital information of all the music that is going through, Spotify has not decided that they're only going to provide their service to companies that are making TPM protected devices that are actually relatively more effective than the other ones. I find this idea that that these services are only available because of these TPMs to be very confusing, since these services are clearly available on devices that do not have very good TPMs.
So all of these well-designed TPMs on the visual assistant devices, are you looking to circumvent all of them, or can you divide it up between somehow just the firmware and the enhanced audio buffer, or the other ones you're talking about?
What we're talking about today is specifically the ability to make modifications to general purpose computing elements on these devices to the extent to which there is a specific TPM that is designed for protecting the digital music content or other media content that is flowing to the device. That is not what we are specifically asking about today.
Do you know, would that be implicated, though, if you were allowed to do what you're seeking to do?
As far as I know, no. If you were to have these separate TPM systems, for example, what you would do very, very simply is you would have encrypted information come from the service, and then you would pass that to the encrypted audio buffer, the audio buffer decryptor. It's a weird term there, but it's essentially just a very, very small circuit, very cheap circuit that would just be doing hardware decryption on the device as it goes from the device accessible memory to the actual audio unit, and that would be essentially an entirely separate TPM that is not the same as this general purpose computing parts.
Mr. Stoltz, and then we'll go to Mr. Hughes.
Thank you. There's a number of points I'd like to respond to, including Mr. Amer's question. I think it's important to look at a bit of history here, because we now have almost a decade of experience with jailbreaking smartphones, lawfully jailbreaking smartphones. And it goes without saying that over that period, the proliferation of smartphones, the proliferation of smartphone operating systems, and the proliferation of apps and of music, video, and other entertainment content on smartphones have all skyrocketed. That is the history against which we're sort of discussing today. So this argument that jailbreaking makes infringement or unauthorized access somewhat easier is an argument that Apple and Mr. Williams' clients raised in 2009. Mr. Williams' clients raised it again in 2012. I believe it was BSA raised it in 2015, and again in the renewal phase of this rulemaking. So that's 4 rulemaking cycles and 9 years. And they've never presented evidence, including in this cycle, that shows a significant impact on the markets for any of those types of creative works. They've presented evidence. They have presented evidence that essentially, look, here's how one might engage in piracy, or here's how one might engage in unauthorized access. We can sit here and spin scenarios about how the ability to get root privileges on voice assistant makes it, in some circumstances, marginally easier to exfiltrate music or other content from that device. But what we need to do is weigh that against this history. which shows that while, yes, there may be a marginal impact, while you may not be able to, in Mr. Williams' words, completely protect the content, there remains enough protection from the TPMs that exist that are not part of the access controls on the that involve installing software or installing and removing software. That impact, should not be considered sufficient to deny an exemption. It wasn't for smartphones, which are still a much larger market worldwide than voice assistants. Against that, they've really provided very little evidence that voice assistants are significantly different. While Mr. Williams' clients might, while they're free to say, well, we'll accept the jailbreaking of smartphones, but we are drawing the line at voice assistants, what they haven't shown is a significant factual difference, particularly weighed against this 10-year history, that could be a basis for decision by the office, on a basis other than the preferences of these companies. So on this question of whether whether voice assistants are different from smartphones and tablets, I think the key point is really what was already made by Mr. Freeman, and I won't belabor it. But in terms of hardware and software architecture, they are quite similar. And against that, I would simply note that Mr. Bell, in his declaration, said that he was not familiar with the specific TPMs in use on those devices, and the opponents have not responded to this question of there being similar architecture. Finally, just to answer Mr. Ammer's question about contracts, I think it's important to note that the customer, the person who is the owner of the hardware, is not a party to contracts between the record labels and music streaming services. And again, we don't know what's in those contracts. We could conceive of a contract that says you must, build the highest wall you can possibly build on this device and oppose any attempt to breach it. But that in itself does not show a diminishment of the availability of copyrighted works for use. It merely shows a preference created in a private agreement between two companies. And frankly, if that were enough to defeat an exemption, if there were language in those contracts that would defeat an exemption, then we should probably just all go home. Because they will use that language in those contracts. The key point, if I may,
just quickly,
and I'll wrap this up quickly, I promise.
Yep.
The key data is, as Mr. Friedman said, all of these forms of copyrighted content continue to be available on platforms with all of these with very, very, very many different degrees of locked downness, if you will, and they continue to exist on smartphones and tablets to a vast degree. That has not changed, and that should be powerful evidence here.
Thank you. Mr. Hughes?
So I guess two wrongs don't make a right might be one of my comments here, but I wanted to go back just very quickly to Mr. Freeman's software of the Cydia impactor. I'm not sure I feel he characterized it quite accurately. In that Cydia impactor, while it does do what the Xcode, which is the Apple's what Apple provides for developers. It takes advantage of that, and what it does is it says, if you pretend to be a developer, you can then use Cydia apps to download free music. To me, that is his description of it was not quite accurate.
Is that something you wanted to submit as an exhibit, what you just held up?
We can.
You just sort of referred
I'm
to
happy
something, and I don't
to
know.
send a copy of this.
Yeah, I think if you're asking us to consider something, it'd be helpful to have it and to let them see it also.
That may be in what I gave you, but
I'm not sure that one is, but
I'll submit it.
the other comment I wanted to make, going back to I believe to Mr. Ammer's comment, was that while the end consumer does not have any contractual relationship with the label, they do have a terms of service. In a sense, they have a contract with Spotify, for example, and part of that terms of service, I believe, says, I'm not going to steal the music if you give me a subscription. So that might be considered as part of the overall legal framework that's constructed for the distribution of music to the end consumer.
And the remedy for breach of that would be terminating the service and potentially a breach of contract suit.
Mr. Williams?
Thank you. So I just wanted to speak about a couple of things Mr. Stoltz said. There's a lot of focus on what kind of evidence can we present of harm from jailbreaking. And as with a lot of these exemptions, it's very difficult, if not impossible, to collect one-to-one evidence showing that this individual person jailbroke their phone, installed this app, and then downloaded our music. We did submit an IFPI music report as one of the exhibits referenced in our initial comments that shows that globally 40% of consumers have been found through surveys to have unauthorized access to music. A significant portion of that, I suspect, is through jailbroken phones. Can I tell you the exact percentage? No. And can I tell you the number of dollars exactly each of the record companies and motion picture studios lost as a result of jailbreaking? I can't. But I think it's safe to say that there were dollars lost, and that as a result there were fewer dollars invested in the creation of new content. One of the things you're supposed to look at is the overall impact of the 1201 system on spurring creative activity. And when you can see that jailbreaking is leading to a lot of unauthorized access, I do think that in itself is evidence that there's harm being done to creative expression and its output and dissemination. Mr. Stoltz was emphasizing.
Really, can I just
yes.
ask one quick question, please, about the survey? So when you say 40% were found to have unauthorized music, do you know how they reached that conclusion? Like, is it just, I'm going to tell you I have, anonymously that I have this, or like, how did they actually reach that conclusion? And I apologize for interrupting, but I figured you could answer that and then move on to your other points.
Sure. So this is, and I'll give you the full title so you can take a look at it. It is one of the things we linked to in our comments. It's the IFPI Connecting with Music Consumer Insight Report from September 2017. And I can't tell you that I know all of the ins and outs of the research project that they did in order to reach these numbers. But if you look at page 19 of that report, it details that their conclusion was that 40% of consumers access unlicensed music, and it talks about a variety of ways that they do that. So I may be able to get you more information about the actual methodologies that they used if you wanted to send me a follow-up request for that. It's not technically an RIAA report, it's a global music industry report. But, the notion to me that, well, music is still available on mobile devices and therefore you should just keep expanding these jailbreaking exemptions because music will still be available. I just don't see that as a very credible argument, because the fact that all the record companies and streaming services haven't taken their marbles and gone home doesn't mean that they aren't being harmed and that they aren't losing money as a result of unauthorized access. And so if that's the standard, that well, we haven't shown that there's no more music available on mobile devices and therefore you should be able to jailbreak anything you want, we're never going to be able to meet that standard. But I do think that you can infer from all of these types of apps that we've submitted evidence of, and there's many, many more of them, that harm is occurring, and the underlying economic theory of copyright is that you need to recoup your investment, and then you make a profit, and then you reinvest that back into the system, and that leads to more output. And so I think if we believe in that economic model, that we've got plenty of evidence that there's been harm done.
Okay, thank you. We are bumping up against the hour, and not just any hour, the lunch hour. So I'm going to quickly, I believe you had a question on a different topic, and I'm going to invite my colleagues to, consider if they have any questions too. I have one question myself, so we're going to try to fit this all in quickly.
Okay, so we'll keep our questions snappy, and if we can keep the responses snappy too, and we appreciate this productive discussion. So this is, I guess, a question for both sides, because listening to Mr. Soltz talk about the past 10 years, how the office has dealt with jailbreaking, one thing I will say is that for smartphones, there seemed to be a good record of non-infringing or licensed or otherwise permissible uses, like specifically in terms of software programs that could not be installed or used on the smartphone. That was also something we looked at seriously and carefully with the smart televisions. It was under a FLOSS license. There were a lot of other programs, and I'm wondering, on the one hand, do we have a similar record of programs that you can download onto the voice assistant devices that are non-infringing or licensed or otherwise, I guess would be facilitated by granting this exemption? And then on the flip side, we have got this packet of information of programs I guess you can download via Cydia. Can you use many of which seem to be sort of facilitating unauthorized access to copyrighted works? Are those equally available in the voice assistant device context?
So, voice assistants are a fairly new category of devices. There's not going to be as large of a catalog of prominent applications, if you will, or lawful applications with lawful uses.
Is there anything
now,
like in the
jailbreaking?
record?
No, if I may, I'm sorry. I'm sorry. Please.
Well, I'm just wondering, like, what specifically you can point to, in the record, for example, of what our applications have been made or maybe made, that we can look at to say, okay, this is what someone wants to do if an exemption were granted for voice assistant devices.
Essentially, they are expansions on Amazon skills. So there are tens of thousands of Amazon skills which are comparable to apps. The problem, the limitation on those is that they run in silos created by the APIs that Amazon exposes, and we had a couple of examples in the statements attached to our initial comments that describe some of those limitations. So for example, a skill that provides a sort of meditation app or inspirational quotes, you couldn't slow down the speed at which the Alexa voice reads them, which was pretty key to that application. That was an example of that. But more broadly, right, jailbreaks are both at this point more difficult on those devices because they are new, and there's no exemption for it. So we are absolutely not going to see as many prominent examples, but examples do exist.
Okay, Mr. Freeman?
Yeah, I mean, one thing that happened, of course, with the iPhone before the smartphone exemption was put into place was that we simply were bold and went ahead And so that was where it was very easy for us to demonstrate all sorts of interesting like jailbreak-specific functionality back even in 2009 for the smartphone exemption. Whereas in this case, due to the complexity of these jailbreaks, sometimes requiring like hardware access, as I mentioned earlier, it's very difficult to show demonstrations of people who are doing things on the jailbroken device already. But there are examples of the same, because there's some of the similar kinds of software that is available on these devices, as mentioned, things like ebook readers or read aloud ebook software, that we can see the same kinds of modifications that you would want to have elsewhere now existing on these devices. Quick comment just to mention that, Cydia impactor, as far as developers, claiming to be a developer. If you're allowed to download software and compile it, I don't think that's you're not really necessarily pretending to be anything. That's just a part of the functionality in the service. We mentioned downloading applications and tools. I just want to, you just mentioned actually that again. I just want to once again reemphasize that essentially all of this functionality is available on non-jailbroken iPhones as well as on desktop computers. I just quickly searched for
I'm concerned about
Spotify.
the availability for voice assistant devices.
Yes,
right?
and so from that perspective, none of this software is certainly available on voice assistants because it's all designed for either running on an iPhone or running on a desktop computer. Similar software could be constructed by somebody, I'm sure. But then again, I will actually say that similar software could be constructed as an Amazon skill. If you simply were to just take the existing SDK as a developer and then just build something that said, hey, I would like you to go download something from Spotify, you would be able to download that because Spotify is available on all platforms.
Right, I guess the theory is that Amazon would curate it, is what Mr. Suck said in a more careful manner.
So that was the theory. However, you can develop for these devices as any user, and so it's in the same way that on the iPhone you can install as a user whatever software you'd like on the device. That's the same thing. I speak at hackathons constantly. These 36-hour college events where students get together in groups of 3, and by the end of the weekend they've put together software that runs on their Amazon Alexa. Amazon didn't curate that. They can then publish that software for other people to utilize. Amazon isn't curating that.
They don't curate the publication of it?
Because you were just publishing it on GitHub, you're publishing it on your website. If you would like to have access to it from the Amazon stores, if you'd like to have access to it, you essentially just like ask Alexa to install it for you.
Right.
Then that's an opportunity for Amazon to curate it. But the existence of that software and the ability for people to download it with their computers, the ability for people to reference it on their devices, that's not something that's up for Amazon to be able to curate.
Correct, got it, okay. Mr. Zuckin, if you had a demonstrative you wanted to show us, now is probably a good time to do so.
Yes, sorry, I was looking for the opportunity. There was a discussion we raised in our initial testimony about an alternative whereby you create your own device rather than hacking an existing device in order to get the functionality that you want. And we raised a technology called Raspberry Pi, which is this open source board. And EFF responded saying that that's like saying you have an engine and that's the equivalent of having a car. And so what I brought in these pictures is just some examples of kits that are available. The most commonly used VR headset right now is made of cardboard and originally shipped Google Cardboard that came in the New York Times. And so similar kits are available to create an Amazon Alexa type device or a Google Voice type device. So as long as I'm talking about breaking open a piece of hardware and soldering a new port to it or something like that, I'm more than able to get one of these devices for cheaper than I'm going to get something from Amazon and make use of the Amazon API to go on and replicate that functionality or add any functionality that I want to create. So my understanding is that while it's not the copyright owner's burden to show harm, but instead to show it's the burden of the proponents to show that they have no means to allow for non-infringing uses, there are means to do so, and people are very creative in providing easy-to-use jump starts into creating devices that would allow for additional functionality while preserving some of the existing functionalities devices have. So that's what these are, is just, you can just sort of see, it's a pretty simple process to put these things together. It's no more difficult than what they're suggesting in terms of hacking an existing device. And I'm happy to answer questions about this, but I know time is limited.
maybe we can, just in the interest of time, we'll get to everyone again, but go to Mr. Williams next, and if you had something you had mentioned about Oracle, maybe say that now too.
Okay, sure. And there's a lot in the opinion, and I think we're going to do Class 7 again when we're in Los Angeles, and it's relevant to both. So we can talk about it some there, but I just quickly want to say first that I think the ability to develop Amazon skills is an alternative. Google has a similar process with instructions on how to do it on the web. The record is pretty small with respect to the types of things that people are not able to do within those environments. I mean, to me, there wasn't much there compared to the potential threats involved. So I do think you're right to point out that there was a more robust record previously when different devices were covered by the exemption. With respect to Oracle, the Federal Circuit was applying Ninth Circuit law. The basis for these exemptions has been historically that the office read some Ninth Circuit cases quite broadly in the interoperability area, and by reading them broadly, decided that an exemption was justified. What the Federal Circuit does is go back to Connectics and those older cases in the video game space and say, well, look, the Ninth Circuit took a look at what they were doing there and said, this is only modestly transformative. And the reason that it ended up being transformative at all was that what was being done was they were opening up the software just to look at how it worked, and then they were developing entirely new products that didn't use any of the expressive elements of that software and putting them into the marketplace. That's not what is done when a device is jailbroken. The firmware, at least based on what the proponents have described, is essentially just copied after it's hacked with a very minor adaptation, and then reused to do what it is that they want to do. And so that copying...
Well, it's jailbroken for the purposes, I guess, of enabling interoperability, and I think maybe also consider 1201F and the purposes behind that. I'm not sure how, I'm not quite following how that reverses the office's previous interpretation of the case law.
In the Sega case, what was at issue was developing a competing platform on which to play independent games or to play the Sega games, and that's not what's at issue here. It's just taking the same copyrighted software and using it to basically achieve the same purpose with slightly different objectives. And so that copying under the Oracle decision, I think it's a stretch to say that it's a fair use, and that's been the basis for the reasoning. It has not been Section 117 because there's all kinds of other questions that have to be answered there. And the other thing about Oracle is it really disposes of the notion that just because software has a lot of functionality that it needs to be treated differently than other types of works. And I'm not saying that it's never treated somewhat differently, but I mean, if you look at the opinion, they're citing other cases in all kinds of other areas of copyright that aren't just about functional software. And so I really think the opinion speaks to the fact that software is not a second-class citizen, that it gets the full protection of the Copyright Act, and I do think it impacts some of the prior reasoning, but I submit that to you to decide. The only other thing I would mention is I think you were right to raise 1201I. I think the fact that it may not fit perfectly what the proponents want to do doesn't mean that it's irrelevant. It just means Congress decided to do this differently, and one thing that Congress didn't want to happen was that other types of infringement or unauthorized access results from the fix of this privacy issue.
Do you think 1201F already enables them to do what they would like to do?
I don't. 1201F, I think, is based on these cases I was discussing, which is involving just getting at the copyrighted work so you can analyze it, and then you go and create your own work that achieves a similar purpose or that interoperates with it. So you don't take the work that you're analyzing and copy it, and you don't take the work that you're analyzing and create a derivative work from it. That's not what was at issue in those cases, and I think that's why 1201F is written the way it's written, because it basically says you're allowed to circumvent to get access to the software, study the software, but you're not allowed to get access to it for the purpose of creating a derivative work to do what you want to do.
Mr. Stoltz?
Yeah, so few points, and I will try to be quick because I know we're all hungry. First of all, responding to Mr. Zook's points about, I guess, malware. Jailbreaking is for power users. It, in general, it renders, is a somewhat more risky activity than using a device precisely in the ways that the manufacturer intended. It is no less important, and it is widespread. There are millions of those power users. So that the owner of a device might choose to make themselves more vulnerable to malware. They will, probably be more sophisticated and able to avoid malware, but also, they are taking that risk voluntarily in return for expanding the functionality of the hardware that they own. Let's see. Google, responding to Mr. Zook's demonstratives, there is no device that you can build from parts that replaces the functionality of an Amazon Echo or Google Home. At best, they can do a few things, perhaps turn on a light with voice control. They certainly won't be able to access Amazon Alexa, for example, and expand the capabilities of Amazon Alexa. So building one's own device from parts is not a real alternative here. Moreover, it's not an alternative for devices that are already existing and already in people's homes. Part of the value of jailbreaking is the ability to keep a device working after the manufacturer cuts off support, to install security fixes before the manufacturer does. Building your own is not a fix for the device that you already own. And then to respond to a couple of Mr. Williams' points about Oracle. The Oracle was wrongly decided in many different ways and completely misread the Ninth Circuit precedent. It is not binding on the Ninth Circuit or on any court in this country except under the odd circumstances at which it reached the Federal Circuit. And I think that Mr. Williams mischaracterized the Sega and Sony cases out of the Ninth Circuit somewhat. And this distinction is important. Copies were made in those cases. The defendants made copies of software, but they did not proliferate copies. The Copyright Office here in the Register's recommendations in the last 4 cycles has always said they don't find jailbreaking to be transformative because it's using the firmware for essentially the same purpose. We don't entirely agree with that, but be that as it may, the office has always said that it is nonetheless a fair use. And that fair use is actually very close to the facts of the Sony and Sega cases. One of those, I believe it was Sony, involved copying to enable writing new games for an existing platform. The other one was copying to enable writing a new platform for existing games. Both of those contribute to the creation of new work, and so does jailbreaking. That logic has been, and the Copyright Office has maintained that over the last 4 cycles. The Oracle decision, as wrong as it is, doesn't change any of that and doesn't really apply here.
Thank you. We'll go to Mr. Freeman, and
Just very, very quickly. I'm sorry to.
Sure.
Sure. I just wanted to clarify that both of these devices, these kits I were talking about, are specifically designed to talk to published APIs at Google and Amazon. They're not just devices that you would create for your own purpose. They are specifically designed to be alternative hardware for the services provided by Google and Amazon.
Okay, thank you.
I hope we can see that and get details on that.
I can actually respond to that point. In the past, I've actually worked on building a voice assistant system. One of the things that's really complicated is to be able to, in a room, talk to the device, and it can actually hear you. It's the kind of thing where you start to try to find like wall-mounted microphones. You try to find, if you just like a typical microphone like this one is not going to hear somebody on the other side of the room. Certainly not the kind of microphones that are available. Even like the one that's on my iPhone is not really designed for somebody across the room, and it's got a lot of advanced hardware. These voice assistants are designed with 6, 7, 8 microphone arrays that are carefully calibrated against each other in order to do noise cancellation. There's advanced firmware that's on these devices in order to figure out the echoing within a room. Building a voice assistant from a Raspberry Pi to me honestly just seems a little bit absurd. It just would not function anywhere near, but really would not even provide even a partial bit of the functionality that you would get on these devices, even if it can talk to the same APIs. To respond to the comment earlier, to continue a little bit just on the malware. Malware is on a lot of these devices is due to the device being jailbreakable, not due to the device being jailbroken. So the fact that the device has a vulnerability in it that can be exploited, that there is a mistake in it, allows people to, for example, download apps from all sorts of different places, and then it can take control of your phone. The ability for people to send you a text message that then has you go to a web page that takes control of your phone. That's because your phone is jailbreakable, not because the user it was jailbroken. And this is a very slippery, confusing thing that oftentimes ends up occurring, where people blame the jailbreaks and they blame the circumvention mechanisms as opposed to blaming the bugs in the original software that was being that was allowing the circumvention. Even if people were not allowed to do the circumvention, well, certainly people weren't allowed to hack into your phone either, and they're doing that anyway. As far as skills being an alternative, skills are definitely an alternative to infringement, but they're not an alternative to the work that we want to be able to do. As skills are not something that allow you to disable the touchpad on a device that's accidentally uploading your information. Skills are not something that you can use in order to determine and disable software that's running in the background in order to determine, in order to essentially be providing more information to Amazon and Google. What the skills are able to do is they're able to demonstrate that the circumvention has nothing to do with the infringement. You can build a skill that just is able to use that same speaker in order to play music that was incorrectly, improperly, illegally downloaded from these various services. And finally,
I think, if you could just wrap up quickly. And
I've got one last point, and then I'll be done. And then as just to mention on the Oracle thing, so the Oracle was about the Oracle result was about actual copying, and I just want to provide from the 2010 Federal Registrar Notice of the Library of Congress final ruling, the amount of the copyrighted work modified in a typical jailbreaking scenario is fewer than 50 bytes of code out of more than 8 million bytes, or approximately 1/160,000th of the copyrighted work as a whole, where the alleged infringement consists of the making of an unauthorized derivative work, and the only modifications are so de minimis. The fact that iPhone users are using almost the entire iPhone firmware for the purpose for which it was provided to them by Apple undermines the significance of this factor. And again, there was no copy.
Do you think the same logic would apply to voice assistant devices?
The exact same logic applies to voice assistants. We are not copying the firmware. We are not modifying, distributing the firmware. We are instead running the firmware on the device. We are making modifications in memory momentarily of, as we're seeing here, fewer than 50 bytes out of 8 million bytes. This is a de minimis modification in memory, and the previous cases that had determined the case law, and for example, Nintendo versus Galoob and things related to the Game Genie apply in this case.
Thank you all very much.
I think that's it. We'll be back.
Thank you.
Thank you.
Thank you very much.
This has been a presentation of the Library of Congress. Visit us at loc.gov.